Okay. Can you all see the PowerPoint?
Yeah, we can,
Okay, cool.
or I can at least.
Yeah. Okay. All right. Okay, so first things first, I was looking over the material. There's a ton of content to cover. So it's going to be a pretty like high level overview. There were some materials that I chose to cut off. You know, ideally, I think that they're not they were in super big topics. That being said, if you don't see something here, make sure you go back and look at all the material that he's covered in class because it's all fair game. Um, After going over all the new content, I'll let you all ask me any questions, but obviously feel free to stop me, as I'm going through the material. And then I'll just wrap up by giving you all, some final exam tips, both for that apply for his test, but just in general throughout law school. Okay, so let's go ahead and get started. So we left off with all the way back with statute of frauds and real estate contracts. And the general requirement for statute of frauds, if you'll remember from contracts class, is essentially just that the instrument needs to be written and then signed signed by the party to be charged, which essentially is signed by the party against whom, like whoever the defendant is, essentially needs to have signed the contract. I guess since we're in real estate land and in property, there are two additional requirements. It needs to specify the description of the real property. So, for example, if you were to say, I think he gave the example of just saying like, I have 10 of 20 acres or whatever, but it doesn't specify which of the 10. That's ambiguous, and that wouldn't be good enough. It also needs to state the price. And then for this one, something like fair market value would probably be sufficient. In the event that there isn't a written contract, this is I think it was a Lohmeyer case, where there are two exceptions. One, if there's been part performance, or if there's been estoppel. With part performance, there needs to be I think it was, yeah, 2 out of 3 of like certain requirements. And those 3 requirements are payment of all or part of the purchase price. He said that a minimum deposit would probably be insufficient, so it needs to be pretty substantial. The person needs to have taken possession of the land, and or made like substantial improvements on the land. So you need to have at least 2 of those 3 in order to rely on that theory. And then the estoppel one is essentially very much like the contract theory. So there's been a promise, there's been a reasonable reliance from the promisee, and then there's been like an inequitable result. So those are kind of like the 2 ways out of a contract that was not written down in compliance with statute of frauds. Okay, so then he covered this later in class. I kind of thought might be a little bit easier for me to explain it at the beginning. So whenever, let's just say you sign the contract, what does that get you? You're at that point, you're in the executory period. And then during that executory period, the parties can rescind the sales contract for a number of reasons. He mentioned contract theories, so the usual fraud, mutual mistake, contract terms. So if someone says we need you to have like certain financing and they can't obtain them from the bank, then in that case that would be an avenue for that party to rescind the contract. Then if there's any like federal or state laws that have been breached, that would be another avenue. The 2 examples that he gave, I think both were federal and then both concerned environmental statutes. So just kind of keep that in mind. But I guess the more common ones that you'll see are breaches of implied common law duties. And then the 2 that you all saw were the implied warranty of marketable title and then the duty to disclose defects. Okay, so the first one, the implied warranty of marketable title, This one is essentially okay. So marketable title, I guess, like moving back a little bit, it's essentially just the buyer saying, "Hey, like there's a legal problem with the land, and they want out." So if there is a problem with legal title, um, it's not automatic grounds for the buyer to be able to rescind the agreement. Remember that all it does is the seller still has an option during that time period to cure whatever issue is going on, and they have until that closing date. So then the question becomes, okay, what is what's considered a violation? And for the low, okay, sorry, I made a mistake. So the case for statute of frauds was Hickey. I just remembered. Lohmeyer, which is the one that I cited before, is actually about marketable title. Sorry, so sorry for the confusion. But anyways, okay, so in Lohmeyer, you guys saw that there were covenant violations. And for these ones, if you're out of compliance with either zoning or restrictive covenants, you can bail. But remember that zoning ordinance per se, like if there is a zoning ordinance, that's not necessarily grounds, assuming there aren't violations of that zoning ordinance, that's not a ground for you to rescind the contract, because that just applies to everybody. So that wouldn't be sufficient. But then also, I guess another one is if the interest within the marketable title is incorrect. So let's say the seller gives someone like a fee simple absolute, but they only possess a life estate, they clearly can't give that. So then that would be a violation. And as I said, like the zoning restrictions or restrictive covenants, those would be like encumbrances. So those would also, depending on the circumstances, that might be grounds for rescission. Yeah, and then after merger occurs, which is essentially when the deed has been delivered, this contract remedy goes away. Okay, so then the next common law duty or common law theory for escaping a transaction they all saw during the pendency of the executory period was the duty to disclose. And then this one, essentially the buyer just says, hey, there's something wrong with the physical premises of physical premises, and I want out. So remember that when you're looking at duty to disclose, it's only about the physical like conditions or circumstances of the property. So at common law, he mentioned, and it's still kind of a minority position, it was caveat emptor, which means, like buyer beware, essentially buy at your own risk. There was an exception, which kind of a minority of states use, and if it says, if a seller created a defect, then, the seller can't, the seller would still be on the hook. But the majority position is that the seller has a duty to disclose known material latent defects to the buyer. So what do each of those terms mean? So material defect means that it's substantial, significant, and essentially something that would affect the value of the property. So a good way of analyzing something as material is just asking yourself if it would affect the value of the property, or would somehow affect what a buyer would offer to purchase the land. When it comes to knowledge, the important thing to remember is that it's only the knowledge of the seller, and it has to be something that the seller actually knows. It's not well, the seller should have known about this. That doesn't really count. And then there was something else with that. I think so if the buyer knows about a condition also, like if it's just well known, then that's not an avenue for the buyer to rescind the contract. So it's only when the buyer doesn't know, the seller has the knowledge and doesn't share it. And then the last condition, latent, just means, something that can't be like visibly seen. There were some limitations that he talked about. One of them was that on-site defect, and that was a strong case. And then for that, he gave two examples. So he said, if there was like an airport that was 2 blocks away, and it was disturbing. I don't know, like every night, you hear just planes, the sound of planes, and for whatever reason, when you signed the contract, you just didn't know. That doesn't count because that's not a condition on the land. But you can kind of get creative with those arguments. Like he mentioned, there was another case. I don't remember the name of it right now, but he said that there was like some garbage disposal, like landfill, a couple blocks away, and it was somehow impacting the water quality, of the house. So then in that case, that was considered to be like an on-site defect. So be on the lookout for those kind of things. Again, might be a stretch, but who knows, might come up. And then like the other common law duty, this one also goes away at the time of merger. And it can be waived. So if there's an explicit waiver, that's okay. He mentioned that as is clauses are a little bit unclear. So it's not settled law, I guess, and it would depend on the jurisdiction. Okay, so then once the delivery of the deed occurs, the executory period ends, at which point all the contract remedies are like merged into the deed. And then the only avenues out are, or I guess for damages, are these 6 deed warranties. And they're broken up into like 3 present assurances, 3 future assurances. So then the covenant of season and the covenant of right to convey, he said they're pretty similar, like they go almost hand in hand. So with the covenant of season, it's essentially the grantor saying that they own the type and amount of land conveyed. So he gave the example, like I have a fee simple absolute and 20 acres, like that's what I have. And then covenant of right to convey means exactly what it says. You have the legal right to convey that land to someone else. He said usually, as I said, they go hand in hand. The catch, I guess, the one time probably where they wouldn't is if you have like a trustee beneficiary situation, because you have the right to be there, but technically, there's a difference between being able to like enjoy the land and being able to convey it. So that's kind of the one exception, but again, very, very minor. Most of the time, they'll go hand in hand. And then the covenant against encumbrances, essentially think about this like marketable title. It's just the grantor saying there will be, like no liens, mortgages, easements, stuff like that. The covenant of general warranty, it's a promise that the grantor will defend against the grantee against any claim of superior title. So if a third party were to come in and say that if they were to tell the buyer that they have superior title, then the grantor needs to defend the grantee's title in that situation. The covenant of quiet enjoyment, just saying that the grantee will not be disturbed by anyone holding superior title. And further assurances, I kind of see this almost like a catch-all. So it's just saying, the grantor will take future steps reasonably necessary to cure title. So, like if a deed lacked a signature or something like that, that's when that you kind of see that come into play. Okay, so then the 6 that I just mentioned were like the common law, and then but then there's these 3 different type of deed warranties that you generally get: the general warranty deed, the special, and the quitclaim deed. So the general, it guarantees all 6 warranties. And it doesn't really matter whether the grantor caused the breach or someone prior to the grantor caused it. The grantor essentially takes up the responsibility. Think about this almost like insurance. So what he said is that generally general warranty deeds will be baked into the price. So the buyer will typically pay more money in order to get the general warranty deed. The special warranty deed, on the other hand, it guarantees all 6 warranties, but only if the grantor breached it. So, there were some like predecessors in title that caused the breach, that wouldn't be something that the grantor would cover because, the grantor didn't cause it. And then the quitclaim deed is essentially just like no guarantees of any kind. This is the one that he brought in the example of, forget who, but like a salesman essentially going up to a kid and saying, "Hey, I'll sell you whatever interest I have in the Brooklyn Bridge interest was zero, that's kind of, think about that example when you think about this. He said it usually it's like a red flag if you see a quitclaim deed, like something will look fishy. Kind of the two times I guess that you'll see this is if you have um like an interest in land and you're trying to sell it and you know that a family member might have like some minimal interest, you'll try and get a quitclaim deed to kind of relinquish whatever rights they have. Or if someone has property, then they get married, and then they want to have they want to own the property like as joint tenants with right of survivorship, then they would effectuate a quitclaim deed in that respect as well in order to do that. Okay, so then you all, yeah, Tenny?
I had a quick question about the remedies for
Uh-huh.
breaching these covenants, because I know
Mhm.
for the present one, I think that's based on the purchase price, but I wasn't sure what the remedy was for a future covenant if no eviction occurred.
If no eviction occurred, I think it still damages at the fair market value at the time of the sale. But let me get back to you on that one. Hold on.
Okay.
Yeah. Actually, could you type it up in the chat box? And then, yeah, that might be a little bit
Yeah,
easier.
sure.
Thank you. Okay. All right. Where were we? All right, so mortgages. All right, then you all looked at mortgages and the distinction between a mortgage and a promissory note. So mortgage, remember that it's just a remedy. And it gives the creditor the right to foreclose on the collateral property. And then the promissory note is essentially just like the contract that the usually can be sold. And he described it as kind of like a detailed IOU. So then you have transfers. Transfers. And then he mentioned the mortgagor ones and this distinction between take subject to and assumption. I'll preface this. I mean, I had a couple of questions about this in office hours, and both of those he said that what were they called? The like as is clause, or the not as is clause, sorry, I'm blinking. The due on sale clauses. The due on sale clauses essentially kind of like render them moot. Like by industry custom and standard, they're not really available, but you should still know about it because he mentioned them. So the take subject to is essentially just whenever you have someone who like for someone who owes the mortgage and then they sell the house to someone else, and then that other person like walks into the house, but the person who was previously living there is still the person responsible for the mortgage. So if they stopped paying, then the bank could foreclose on the house, and then that just that the second tenant or buyer, I guess, would be foreclosed on. Versus assumption, think of this just like an assignment in the lease context that you all saw. It's just a person taking subject to the mortgage. So then that person steps into the shoes of the previous person. So they're now the ones that are the ones that need to make payments. But again, the due on sale clauses pretty much make those things, they're not super relevant now. I think the transfers is much more relevant for mortgagees because these promissory notes get swapped all the time. And what it does is essentially the new owner becomes what's known as the holder in due course, which requires transfer for value in good faith. If you have those two things, then the holder in due course has a defense against debtor's claims. Yeah, and that's pretty much kind of what he said. He said if there is a foreclosure, kind of what happens. So just some like definitions. So there's a deficiency. Let's say the house, like the mortgage was for 400,000, but the house only sells for 300,000. That excess amount, the 100,000, the mortgagor still has to pay for that amount. But remember that there are some exceptions. Like I think it was California doesn't allow for that if it was a residential property. So keep that in mind. Then surplus is kind of the opposite. It rarely ever happens, but let's just say, same example. So the house was worth 400, and then at foreclosure it sells for 500. That excess 100 would go either to junior creditors, or if there are no junior creditors, then it would just go back to the mortgagor. But again, not super common. And then just remember that there are different things that can happen, I guess, after the foreclosure period. So he said most states allow reinstatement, which it's essentially when the debtor pays off all the missed payments in a relatively quick period of time. If they do that, then they can avoid foreclosure. And then the statutory right of redemption, foreclosure has already occurred, but then the debtor can just repurchase the property essentially by paying the full sales price plus whatever interest and associated costs. Yeah, and then he did mention Texas doesn't have the statutory right of redemption. All right, so title recording. So the first thing to note here is that recordation does not mean ownership. Super important because I know some people sometimes get confused with that. Recordation essentially just creates a public record of ownership transfers, and you can record anything kind of related to land, so mortgages, deeds, easements, stuff like that. The application, I guess, and the import of recordings, recordation are these recording statutes that you all talked about. So the background rule is first in time, first in right. And then these other statutes, the race notice, come into play whenever you have a second purchaser. And then I guess the analysis is under what circumstances does the second purchaser, under what circumstances can they overcome, the first person's interest. So with race statutes, it's essentially the first person to record prevails. He mentioned this is super rare. I think only 2 states have it. And then in those particular states, notice is irrelevant. But the catch is that you have to be a purchaser for a value. So, you can't gift the property to someone else. And kind of the rationale behind that, he said, is to avoid fraud. And then with notice statutes, you need to have, it's whoever the subsequent bona fide purchaser is, they prevail. Bona fide purchaser just means that you didn't have notice of a prior transaction and that you're a purchaser for value. And then with race notice, essentially combines the two. It's the bona fide purchaser for value who also records first. Yeah, and then let's see. Okay, so what does it mean? Like, what does notice mean? So it can be either actual, of like a prior transaction, or it can be imputed or constructive. So imputed, it's kind of like that agency concept. If like an employee of yours knows, like your real estate agent, if they know something, then the law will deem you to have known about that. Record notice is, something's recorded, then you'll know. And then inquiry is essentially if something looks odd and that would have put a reasonable person on notice, and they should have inquired about it, that's considered inquiry notice. He did talk about one case essentially where there was a tenant living on, or like another person that wasn't the owner of the land living on the property, and normally that would have caused inquiry notice. However, it was just a tenant, so because of that, kind of it didn't like rise to that level. But just keep that in mind, like anything that would look suspicious kind of would trigger this inquiry notice. Yeah.
Yeah, 2 things. First, I posted another question in chat just about race jurisdictions.
Sorry, I can't see
More
it.
specifically about inquiry notice.
Yeah.
Does the odd thing that you noticed have to be specifically about a potential title issue?
Specifically about a title issue. Yeah, and yeah, anything that would, well, yeah, well, I mean, I would think so, yeah, because so the example that he gave about like the tenants, that would be a title issue, right? Like something that would essentially cause you to think, hey, like something is odd with the land. That can be title, or that can be someone like living on the land, but essentially someone conveying an interest that they wouldn't be normally able to convey. If that, triggers an inquiry, then that's what would prompt this inquiry notice to apply.
Okay.
And then what
And
was your yeah, you said you had a second question, right?
yeah, it was about race jurisdiction. I'd put it in chat because it was a little
Hmm.
weird, but
Let me open it
basically
up 1 second.
you'd said that they have to be a purchaser for value. So I was just asking if the first recipient got it as a gift and
Mhm.
also recorded first, does that mean they still can't win?
Oh, that's interesting. Okay, so the first one got it as a gift, and then they didn't record.
I mean,
Well,
no, they
okay.
did record it first.
Um, no, I think that would be fine because so what it's meant to do is essentially it's trying to prevent that fraud, right? But if the first person got the gift, I mean, there's no requirement that there's a D transfer, right? I think he mentioned this also in class where, if you're super wealthy and then you transfer land, that presumably is like okay. There wouldn't be an issue to that. What this is trying to prevent is more like a fraud situation from going on. But if you received it as a gift and then you record it, then the rule for first in time, first in right would kick in, right? Because it's still that one person. This only ever comes up if you have like two different people disputing. Um, Sorry, I got a notification. So we have 10 minutes. But as I've told you all before, we'll just like pick back up. Yeah, so it only kicks in if you have like two people competing for the same interest. Does that make sense?
Yeah, I think that makes sense. So, like, I guess it only applies if the race statute exception could possibly apply,
If the
basically.
Yeah. So if I'm understanding your hypo specifically, so you said so if there is someone who receives something by gift and then they record, is that right?
Yeah, and then
That person records the
yeah,
person
and
who
then like
gave the gift.
the original owner also sells it to someone, like that same property.
Mhm.
So like then
Well,
there's
under
like a
a race,
dispute.
yeah, under a race statute, though, that wouldn't be an issue, right? Because that
Yeah.
person would have recorded. So then it really it wouldn't come it wouldn't play it wouldn't go into effect, I guess is the way to say it.
Okay. I mean,
Yeah. Go ahead.
I guess I was just thrown off by the wording of the slide where it said the winner had to be a purchaser for value. Because I was thinking
Um,
if they
so
would have won the race normally, but they had gotten it as a gift, does that mean that they still lose?
No, 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 no. Because what this is meant to say is, it's meant to address the situation where the seller sells it to a party and
Mhm.
then sells it to, let's say, like a cousin or someone, after the fact, and then that second person goes and records, right? So then it's essentially trying to prevent fraud from occurring. That's what's going on. But in your hypo, there is really no fraud because it's meant to be a gift, and that's the first person that gets it, right? So,
Okay.
yeah. So that's kind of think about like the policy rationale. It's mainly to prevent fraud from occurring because then otherwise people would just be selling land, um, and then like turning around a minute later and to another party gifting it, and then they record, and then the person who they sold it to really got nothing from it. So that's kind of what that is meant to prevent.
Okay.
Yeah. Okay. Okay. So then, okay, I think I covered everything here. All right, and then the shelter rule. Okay, so the shelter rule, think about this as a relationship, kind of the same thing. So the relationship between parties. So this, I think the example that you all got was, so if you have O sells to A and then O sells to B, but neither of them know the transaction, then B would be a bona fide purchaser for value. And then if B wanted to sell afterwards to C, um, the shelter rule essentially kicks in. And then it says that the bona fide purchaser status of B essentially transfers over onto C. So then in that case, even if A came to C, telling C about the transaction, and then C would have knowledge of this prior like arrangement, because B had bona fide purchaser status, that would carry over onto C. The important thing to remember, and I guess the catch with the shelter rule, is that remember it's on a transaction by transaction basis. So in the example that I just gave, if C were to have bona fide purchaser status arising from the shelter rule, like carrying down from B, if there's a subsequent transaction, and there was actually a hypo about this, where B then like mortgages to D and then subsequently sells to C, but C knows about the mortgage, the shelter rule would only apply insofar as the O to A transaction is concerned, like, and then O to B naturally, but not to the mortgage, because there's essentially like no bona fide purchaser to travel on to C. Like the only reason that C has it, in other words, during that first transaction is because B first had it. So keep that in mind. Like the way that I usually do the shelter rule thing is break up the transactions so that you can clearly see which interest, like who has been a bona fide purchaser status, and then how does that carry on to the parties. Okay, so then you all looked at easements. And then easements, so remember, these are like non-possessory rights to use the land. And think about usually like access paths. That's generally what we're talking about here. The two big buckets are express easements, which are like written down, and you can clearly tell what they are, or they're implied. Usually like from certain circumstances, I guess, that would lead you to believe that there is an easement in the absence of one that is expressed. So then these are the four: easement implied by prior use, easement by necessity, easements by prescription, and easement by estoppel. Let me double. Okay, yeah, I was gonna say I thought I had more slides. Okay, so implied easement. So for this one, you all looked at, this is the Emmanuel case. And then with implied easements, they essentially arise whenever you have a separation of property. Wherever there's been a severance, that's when you're going to have this. However, there needs to be like three conditions. So one, severance of land that was previously commonly owned. And then there's an existing apparent and continuous use of one parcel for the benefit of another at the time of severance, and then a reasonable necessity for that use. So in the Emmanuel case, there was, the land was previously held in common ownership, so that was not an issue. But remember that it failed because they didn't have that second element. I think it was a driveway in that case, in that case. And then obviously there was like no driveway because I think it occurred in 1890 when cars weren't really common. So that clearly didn't exist at the time of severance. The reasonable necessity component, think about this in terms of if there's a disproportionate like expense, I guess, associated with it. And then in this case in particular, there was one because the Emmanuels would have had to pay for like offsite parking, or maybe they couldn't even have used their cars, they would have needed to get bikes, something of that nature. So that's what we would consider to be like a reasonable necessity. A minority of jurisdictions, remember, so that's under reasonable. A minority look at like a strict necessity approach. So it's just like, is it strictly like necessary? Under those jurisdictions, maybe it wouldn't come out that way. Like maybe they would say, hey, cars maybe are not, kind of difficult to apply. But again, that's like a minority of jurisdictions. All right, so then you all looked at easements by necessity, and this was I forget the first name, but this was like the one in Vermont. And essentially this is whenever you have land that's landlocked, and obviously like there was previously land that was owned and then cut off, and now there's a landlocked situation that's going on. There will be an easement by necessity if it's essentially necessary, I guess, to get to the land. So the historical and the minority approach for this one is that there's strict necessity to get to the land. So in this particular case, I think they said that they could have like gone on a boat and gone through the lake to get to the land. That would be like, I guess, a very strict necessity, right? But the majority approach is that it's reasonable. So using a boat, clearly not reasonable because, especially like when we're talking about Vermont, it can freeze. The water, you can only do that for certain months out of the year. And then also it's just like a massive inconvenience, right? So he did say like the narrow holding of this case is that water is never practicable access. So kind of keep that in mind. But again, like the main thing is that there's been severance, which leaves an estate locked, and then look at how necessary that easement is. And then he did mention that this terminates when the landlocking ends, which is considered like an expiration, and I'll get to that in a second. But actually, okay, so it's going to kick me off like any minute now. So I'll stop right now and then I'll pick back up. So I'll exit out, log back in, and yeah, I'll see you all back in a minute. Okay. Thanks for letting me know. Okay.
Yeah, the thing I was actually going to ask though was about the California rule, and then I
Yeah.
thought, oh, I can look at the recording, and then I realized, oh, it's not recording. So
Oh, I'm so sorry. Okay,
that's
well,
all good.
do you have any questions that I can answer about the California rule?
I guess, I mean, no, not really. I guess was the whole arbitrary and capricious thing, because that's something I had down from the slides. Is that
Mhm.
referring to the unreasonable standard?
Yeah, that could be a way to prove that something is not reasonable. So if there's like just no connection to the land use. So I think there was a hypo that you all saw. It's like it said something to the effect of like people need to wear I don't know, like certain types of clothes. Like it's clearly not related to the land. Like there's like no rational connection between the use of land and whatever clothes you wear. So that would be like something that's arbitrary. So it wouldn't really be like reasonable. Um, so yeah, it's like there's different examples of that, but yeah, arbitrary is one way of proving that something would be unreasonable. Same thing with, if it's like violates a fundamental public policy, it's like a way out of that as well.
Yeah, but those are two different views, like the California view and the restatement view. Like they're not
Yeah.
all part of one analysis.
No, 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 no. No, they're two totally different ones. So the restatement one is a little bit um I would say harder to get out of because it needs to be either public policy or there's the constitution or the law or statute that needs to be violated. With the California one, it's there's like more ways, like this arbitrary that thing that we're talking about. Does that make sense?
Yeah, that makes sense.
Okay. Okay, so we were talking about terminating covenants. I think I mentioned to, yeah, so I finished with release. Okay, so merger, um, essentially kind of the same thing as what I mentioned in easements. So if there are two like separate or more parcels that are subject to a covenant, and then one owner goes ahead and buys like both of them, then the covenant evaporates. Condemnation, same thing. The state intervenes, takes land through the eminent domain power, then that terminates the covenant. Um, Unclean hands. He said that this was like an equitable theory of non-enforcement. So it's just think about it like if you yourself are violating the covenant, then you can't sue someone else for violating the covenant. Like that would be kind of crazy, right? So that one I think makes sense. Acquiescence. It's essentially like if you let other people not comply with the covenant and then you try to enforce it against other people, then we're not going to let you do that. It's different than abandonment, which we'll get to in a minute, only in the sense that it's like narrower. So think about it like those two kind of similar, but just in in a more narrow sense. Latches, this is kind of like statute of frauds related, and it's really like about delay. So if you delay enforcing the covenant, or like the violation, I guess, for a long enough period of time, then clearly like that prejudices the party against whom you're enforcing it, and at a certain point we'll say that you lost your rights because you didn't enforce it within a certain period of time. It's just I guess the only difference between latches and statute of limitations is that statute of limitations are clearly a product of statute, and latches are a product of common law theory. Changed circumstances. So this was the Vernon case. I think that's the right name. Vernon Township. That's the case that you all looked at. And then in that one, essentially you ask if the purpose of the covenant has been altered or destroyed by changed circumstances. And then you want to make sure that, like, in order to rely on that, the catch is that there can't be any substantial benefits that are still accruing to residents from the enforcement. Abandonment, this was the Fink v. Miller case that you all looked at. And I think the most important thing to say about this is that if you meet prong one, like, the number, nature, and severity of the violations is just like so extreme, that's all you need to do. Like, you can stop your analysis at that point. But if that's not sufficient, then you look at the other things. You look at the prior acts of enforcement, and then whether it's still possible to realize the benefits that you had intended to gain from the covenant without enforcement. So another way of thinking about that third one is essentially think about, like, if uniformity in the Fink case, if uniformity is what they really cared about, and 80% of the people are not in compliance, then enforcing it against the other 20%, really is not going to change anything, because you're still not going to get that uniformity. Okay, so then moving on to takings. So there's this chart that might kind of help you all out. So you should start off first by asking if the taking is a regulatory or a physical one, because if it's a physical one, then you're just done. And I guess that would kind of be like Loretto, or I guess Loretto and Lucas are more regulatory, so we'll get to that in a second. But yeah, if it's physical, then you're done. Like, that's the end of the inquiry. If the taking arises because of a regulation, then you should ask yourself if it's trying to regulate a nuisance or a noxious use. And this was like the Hadachik case with, like, I think it was fumes or something, like brickworks or something like that. If it is trying to regulate one of those two things, then it is a taking. But you should also look at the Penn Coal case that you all looked at recently. And with the Penn Coal case, essentially there are multiple considerations that he talked about, that he kind of extrapolated from the case, like the extent of the public threat, the extent of the property taking, stuff like that. The main one, I guess, that he articulated was the average reciprocity of advantage. And essentially what that means is, like, if a taking, let me see, how do I articulate this? If the taking gets a super great and it substantially impairs another person without them getting anything in return, then that's more likely to be a taking. So it's kind of like a benefit, like burden analysis. Think about it that way. But keep those things in mind, because it's not super clear where the line between Hadachik and Penn Coal starts. But anyways, so if you're not regulating a nuisance or a noxious use, then you should ask if Loretto or Lucas apply. And then Loretto is the case with the cable wires it gets running through. And then the takeaway from that case is that if a regulation is if it creates like a physical invasion of the property and the invasion is permanent, then that's a taking. And then Lucas, this was the houses like being built on the beach or whatever. And then this one said that if there's a regulation that reduces the value or used to zero, then that's a taking. The one thing I guess with Lucas that makes it kind of tricky is that you're hardly ever going to have that because you'd have to have the state kind of go out and admit that the value is essentially reduced to zero. And the state, I guess, could always come back. Well, one, they're not going to admit that, but then the other thing is it could probably argue that the land can still be used for something else. So it's really difficult to prove that the value is indeed reduced to zero from the regulation. But still keep that in mind. So anyways, if those two cases do not apply, then it's deemed to be a taking. Sorry, so they do apply, it's deemed to be a taking. If it's not, then you go through the Penn, sorry, I said that backwards. Then you go through the Penn Central test to determine if it's actually a taking. And then, so with the Penn Central case, there were like 3 different parts of the test. Yes, Edward?
Yeah, sorry, just to jump back really quickly. I think you gave an example for terminating easements by estoppel. Would you mind repeating that? Because I don't really understand that one.
Yeah, okay. So let's just say that you have a pathway, right? And the servient, or sorry, the dominant estate, or this is sorry. Okay, so the servient estate goes to the dominant estate owner and says, "Hey, I'd like to build like a garden through, like on the path of the easement, or I want to build a pool, or whatever." And the dominant owner says, "Yeah, sure, go ahead and build it." And then they build it, and then after the fact, the dominant owner comes back and says, "Hey, like, actually, I'm going to sue you because you built on the easement. So I want compensation or whatever." In that case, the servient owner or the dominant owners is stopped from raising their claim because the servient owner relied on what the dominant owner had told them previously, right? So then it's kind of like an equitable thing. Think about it like that. Does that make
Okay, that
sense?
makes sense. Yeah, that makes sense. Thank you.
Yeah, no worries. Okay, so then moving on. Yeah, so we were talking about Penn Central. So the 3 like prongs to the test to determine if a regulation amounts to a taking is you essentially look at the economic impact of the regulation on the claimant. You look at the interference with distinct investment-backed expectations, and then the character of the governmental action. And the character of, I'll start from like bottom to the top, I guess. So the character of the governmental action, this one is, it's not super clear what it means. Like one interpretation is to see if there's been a physical invasion of the land. Although he did say that if there's been a physical invasion, then it'll already be a taking. So kind of like iffy, but that's one way to analyze it. Another way is to see like if there's been an affirmative burden on the owners. He did say that upkeep is not really an obligation, that it's super invasive. So, keep that in mind. And then another one, oh, we're running out of time again. Another one is that regulations, he was saying that confer benefits are different than regulations that prevent detriments. So if it's just a regulation that is conferring a benefit, that's more likely to look like a taking. But perhaps where I guess it gets more interesting are the other 2 factors. I think those will be probably more determinative. So if you look at the interference of the investment-backed expectation, remember that to go through that analysis, you ask at the time of the investment, like, what did they expect? And then you ask if the law interfered with that expectation. So in the Penn Central case, they bought a train station and they expected to run a train station. So kind of like the lease in the airspace, that was kind of irrelevant because that occurred after the fact. So in that case, the interference was basically 0, right? When you look at the economic impact, you look at obviously the impact on the claimant, but then you ask also like how much does it harm them? So in the Penn Central case, that ended up that factor weighed in favor of the city because Penn Central could still get like plenty of money, I guess, from even after the regulation was passed. They could still extract value. And he was saying that that's kind of like a high burden to meet because like had a check, the reduction in value had been like close to 90% or something like that, and it wasn't held to be a taking. So kind of like just something to keep in mind, I guess. All right, and then wrapping up really quickly, I think, yeah, this is the last slide. So then you all looked at takings for public use. And then in this one, I guess the one thing I'll say is like the rule really comes from Midkiff. And then the Kelo case is just kind of an application of that and seeing how far it goes. But the main takeaway from like takings for public use is that, there's like massive deference given to the legislature. And then the questions that you ask are, one, is there a conceivable public purpose? So it's just like, can you think of anything that would be like, that would confer a benefit to the public? So there was like one example of houses that were dilapidated in DC, and then, that was deemed to conceive of, that was like a public purpose, I guess, like revitalizing the area. And then the second question is if the eminent domain was rationally related to that purpose. Yeah, I don't have a lot to say here because I think you guys, I wasn't in class for this, but I think my understanding is that you all went through it pretty quickly. I guess the main thing to say is, particularly looking at Kelo, since it's the case that you all looked at, essentially just like economic, again, development can be a valid basis. The ends, I guess, is what you look at, not necessarily the means and how like the legislature went about doing it. The two things to flag there, though, is if it's like a relatively small taking, he did say that might be suspicious, or if the taking comes about because it was like a developer proposed it, then that might be something else to look at. But yeah, I'm not going to go over, because I don't think I'm allowed. I'm not going to cover what you all are going to cover in class tomorrow. But it's just one subject, so I don't think it'll matter too much. But at any rate, are there any questions? Edward?
Yeah, I was just wondering if you could explain again the difference between horizontal and vertical privity. I know you said horizontal for covenants and equitable servitudes.
Mm-hmm.
I know you said that horizontal privity only relates to the original parties to the covenant. Is that like, so there's a covenant between two people and it applies to them, but then anyone that gains title to the property after that agreement, it doesn't apply to? Is that how that works?
So think about, so when you're looking at horizontal privity, like the analysis starts and stops at the parties to the original covenant. Even then, like it needs to be like a deed-based, grant-based. Typically when you'll see it is if there's been like some subdivision of land. That's kind of what you saw in the Nivens case. There was land that was like previously held together and then they split it off. There's like horizontal privity in that situation. But what I was trying to say is that like the vertical one, it's only ever whenever there's a successor in title, that's when the vertical comes in. But the horizontal is only ever to the parties to the original covenant. I said that because I got some questions like throughout office hours, and there was some confusion about like successors in titles maybe having horizontal privity, but that's not kind of the analysis. The analysis is you only look at the parties to the original covenant. But again, like it needs to be like a land-based, deed-based situation that's going on. Does that make sense?
Kind of. I honestly think I just have to review that whole section again, so.
Yeah, okay. Yeah, I will just say that don't confuse like privity of contract and privity of estate. That's kind of what I mean by like the land-based relationship with one another. So in the Deepwater case, there was like a right-of-way easement. So then that was land-based. Whereas the vertical one, trying to think about it like another way to explain it, other than like successors and title. But I would look at the hypos, and then see how he labeled like some of the, and actually maybe I think in some of mine. Yeah, so here, do you see how like the S1, S2, those are like the vertical ones? I know it doesn't really help that much here, but I would go back and look at the hypos and then see how they're labeled. And if that doesn't help, shoot me an email and I'll try and find like another way, I guess, of better articulating it. In my head, I guess I just always think about it as successors and title, but I'll try to find another way if that doesn't clear things up for you.
Okay, thank you.
Yeah, no worries. Okay, does anyone have any other questions? It says we have 2.5 minutes, so it's kind of, I mean, obviously, like I'll jump back in, but
Yeah, I was actually gonna ask if you could go over that chart again, the one that I think you said something about benefits for both parties, and I didn't write it down, but
yeah. Oh, so you're talking about the both scenario?
yeah,
Okay, so it's not benefits to both parties. It's so you need to prove that the benefit of the covenant runs with the land, and that the burden of the covenant runs with the land. The catch with that one, though, and I guess maybe a good way of figuring out if you need to do that analysis, is if you have two successors in title. If you do, that's when you need to like run that analysis. But if you're in one of these other ones, so the benefit, this was like Deepwater, the burden, this was Nivens. If you only have essentially 3 parts, think about it this way: if you have 3 parties, you're not going to be in the latter category. If you have 4 parties, like 2 to the original covenant and then 2 successors in title, that's when you need to run like benefit burden. You need to do like both things at once.
sweet, thank you.
Yeah, no problem. Okay, does anyone have other questions? And by the way, don't feel rushed. I just realized we're like we're running out of time. So I'll jump back in really quickly because I did want to give you all some exam tips, like particularly for his test. But anyways, don't feel rushed. I'll log out right now because I'm afraid if someone asks a question, I'll get cut off like mid-sentence. So I'll jump off, I'll go offline and then log back in. Okay, so I'll see you all in a second.